Classroom Talks, where we mentor future lawyers, we foster critical thinking, and simplify the law for the general public. Today, it's such a privilege and honor to have our most esteemed guest, Dr. Honorable Nancy Baraza, who was our first Deputy Chief Justice of Kenya under the 2010 Constitution, and now a senior lecturer of law at the University of Nairobi, joining us to help us understand and simplify to us this topic on how to protect children who are victims of crime. You're most welcome, Dr. Nancy. And please, I know I have mentioned a bit about yourself, but by way of introduction, kindly tell us, how did you get yourself to be the Honorable Dr. Nancy Baraza?
Thank you very much, Dr. Sala, and thank you very much, our esteemed audience. How did I find myself Dr. Nancy Baraza? God has been gracious. I have been around for a number of years, almost knocking 70. And within those years, I have done quite a few things that I believe catapulted me in my stages to where I am now. Of course, I'm a practicing advocate. I'm an advocate by profession. I have practiced from 1982 to date under the firm name and style of Nancy Baraza and Company Advocates. At some stage, I veered off into civil society work because we in our work as practicing lawyers, we came across women litigants, and we just found that they were so disempowered in terms of accessing justice. And a few of us came together. We were young advocates, but under our senior, Honorable Lilian Mwaura, and we formed the Kenyan chapter of the International Federation of Women Lawyers, the famous FIDA. So we formed it basically to help women navigate the law in the courts. It grew from mere representation of women trying to access justice in the courts. It went into a bigger agitation for the rights of women. And we got into law reform, and we got into constitutional reform, and we participated in the constitution making process. I was lucky, I was elected to represent the women in the constitution making process in the Yashpal Gai Commission. I'm also lucky, I actually chaired the thematic committee that crafted the Bill of Rights, which never changed through the processes of harmonization. So I keep saying the Bill of Rights has my footprint there. So we did that. After the constitution making process, I did other things. I was appointed by the president as vice chair of the Law Reform Commission. And there I made it my business to ensure that we get the women or the family-friendly laws that we have today. The Marriage Act of 2014, the Matrimonial Property Act of 2013, the Protection from Domestic Violence Act of 2015. They were drafted under my guidance at the Law Reform, and they were eventually passed into the laws that we have today. What else did I do? Then I ventured into the judiciary. I have never served as a judicial officer before. The new constitution opened a space for any lawyer who qualified to apply to go to the bench. And in our constitution making process, we got to hear from the Kenyan public, from litigants, what they go through in trying to access justice. There were a lot of barriers. There were a lot of challenges. And there needed to be a total transformation of that institution if access to justice was going to be realizable. And I just formed the idea that this is something that I could do. I've been a reformer. So I felt, let me try my luck. And if I get the position there, I will help in the transformation of the institution of the judiciary. And so I applied for the post of the Deputy Chief Justice. And luckily for me, I was appointed as the first Deputy Chief Justice. And I didn't stay long, but within a stint of 1 year, I would say, I framed the Judiciary Transformation Framework, which became the Judiciary Transformation Framework 2012 to 2016 under Justice Emeritus CJ Willie Mutunga. So we embarked on that, and that was my contribution there. How did I land into the corridors of the academia with Dr. Sala? I didn't stay long. I met with a mishap, and so I left the judiciary, and that is how I joined the University of Nairobi, where I have been teaching since 2013. So that's how I landed where I am. If that is any useful at all.
Quite useful, Judge. This is immense wisdom, immense knowledge. You are actually an architecture of most of the laws that we know today. And it is such a privilege, Judge, and an honor to have you on this talk show tonight. I know you are an inspiration to many of the young lawyers. And if you didn't know, this is one of the reasons why your classes are flooding. Yeah, your elective classes are flooding because the young lawyers just want to hear from you to have an experience, and we have no doubt that your footsteps will forever leave a mark in our lives. So today, Judge, as we get into this discussion, we want to benefit from this immense knowledge, experience, and wisdom. And let us start off with a story that was aired on the Standard newspaper on 6th of November this year, where a 4-year-old boy was killed by 2 other young boys aged 10 and 12. Judge, what comes to your mind when you read this kind of stories?
It's sad. It's sad, of course, when a life is lost. But then, and then more so when it is infants or young people involved in commission of such acts. There is a lot of debate around the culpability of the criminal culpability of young people, like those ones mentioned in the article. It's hurting for those who have loved their loved ones, but the age of criminal culpability in Kenya, as we all know, via the 2022 Children's Act, has been raised to 12 years, so that a child below 12 years cannot be found to be criminally culpable. And therefore, if he or she commits such a crime, no criminal charges will be preferred against him or her. Probably at other avenues, probably counseling, probably some other social approaches can be used to try to help that child, but they cannot be charged with that crime. Now, the debate is the unfairness of this. But this is quite grounded in law. It's grounded in international law, in our national law. It is grounded in philosophy. It is grounded in developmental studies. It is grounded in utilitarianism. So that from a utilitarian perspective, a child who commits such an act is better off being rehabilitated through other means other than being charged. In the sense that that child is deemed not to have the mental capacity to commit that act. And if you subject him to criminal proceedings, that will damage that child. And the consequence of damaging that child will have a bearing on society. And it is also confirmed that children of that age can be rehabilitated, they can change as opposed to grown-ups. So that if they are given sufficient guidance, sufficient counseling, the chances that they will change are high. But if you subject them to harsh punishment, then you destroy them. And therefore, you produce hardened people who are more dangerous to society in future. Now, from a developmental perspective, I think scientists have proved that the brain, the part of the brain of a child of that age, there is a part of the brain, I don't know what they call it, which does not mature until a child is about 22 years old. So that part of the brain, which is very vital for making decisions, has not developed at that stage. And so that is another reason. Now, when we come to the legal perspective of it, if we look at the frameworks, international and national frameworks, this I'm talking about the African Charter on the Rights and Welfare of the Child. I'm talking about the UN Convention on the Rights of the Child. I'm talking about our own framework. All of them encourage, or all of them encourage rehabilitation of such a child as opposed to preferring charges against them. And the reasoning behind that is all these things that I'm talking about. So it is hurtful, but it is well grounded.
Okay. And Judge, now where do we draw the balance? Because you have justified the fact that we need to be lenient to a child who is an offender in these circumstances. But how then do we balance between the best interests of the victim and, you know, this child offender who we are trying to be lenient to?
So the underlying principle is the best interest of the child. And in this case, it's the best interest of the offending child. Okay? So that the grounding, the reasons that I have given sort of justify the rehabilitation of the offender. And here we are talking about the child who has come into conflict with the law. So his best interests are taken care of in our law, in international law, philosophically, etc.
Okay, thank you, Judge. And now I think we all agree that children are extremely vulnerable beings. And the Kenyan law that you have participated in drafting really seeks and makes a lot of progressive provisions in protecting children, you know, who are victims of these crimes. Maybe if you can just highlight some of the most common forms of abuses on our children.
our children face a number of abuses, several abuses. They suffer psychological abuse at the hands of even their own parents, at the hands of their guardians, at the hands of their teachers. So they suffer psychological abuse. If a child is abused, is demeaned, is harassed, that is psychological torture, which is very, very common. So they undergo that kind of abuse. And unfortunately, most of it sometimes goes unreported because of fear, and it has a lot of repercussions on those children. They suffer sexual abuse from their homes, their own parents, their neighbors. It's usually the people that they know. So there is a lot of sexual abuse of children, both boys and girls. And it is a very common thing. Although we have a law, robust law, through the Children Act, through our Constitution, through the Sexual Offences Act, through the Penal Code, that protect or guarantee the rights of such a child or protection of such a child. We have them. We have economic abuse, poverty. You know, poverty is very rampant, and the culprits are the most vulnerable, and these are the children. So they face that kind of abuse. They face other abuses. I think there are very many. I don't know which other ones, but there are many. Psychological, social, sexual, economic. There are several.
Yeah, and I know we shall meet several of these in the course of our discussion. And so let's now move on to look at what we should do. Yeah, supposing we witness these different forms of abuses on our children, what should one do? Whether a member of public, a member of the family, what are we supposed to do?
Of course, our constitution, if you look at Article 53, it states quite clearly that a child is protected from abuse. It is their right not to be abused. And it is the duty and obligation of any one of us, everyone, to take up that matter and report it either to the police or the children's officer in the neighborhood, which is near the station, which is near the gender desks in the police station. Any one of us, members of society, can take up the matter, report to the police, report to the DCI. We have all those desks there. So we have those mechanisms. And of course, when children are being abused, sometimes they get injured. So another immediate thing that we can do is save that child from the environment in which he finds himself, in which he's abused. If he is injured, he or she is injured, then medical attention. We can take them to hospital, and the process also report. If we report to the police or to other relevant authorities, then those children can be removed from that environment. If it is a home, which is an abusive home, they can be removed from that home and given temporary shelter. And the Children's Act 2022 is very, very clear. It creates all those institutions, shelters, short-term shelters for children to be removed or moved away from the dangerous environment. If any of those things are happening, then it is incumbent on the teachers, on the parents, or neighbors to take up the issue so as to protect the child.
Okay, thank you very much, Judge. But I'm also thinking of a scenario where, as you already acknowledged in the beginning, most of these abuses happen from people who are closest to these children. And sometimes it could even be the father or the mother, who is abusing the child. What happens in a scenario where we have these close relatives carrying out these abuses, and maybe out of fear, the other spouse does not want to report, because all the mechanisms you've mentioned are about reporting? What is the kind of protection that exists in this kind, or this child will just languish in these abuses?
Of course, we have mentioned the legal frameworks which protect that child. I have also mentioned those administrative things that we can do to ensure the safety of that child. But it is unfortunate, law notwithstanding, abuses continue, and in fact, by the people who are supposed to look after these children. And because of stigma, or because of wanting to not to expose or endanger the family, then even mothers opt to keep quiet as their own children are being abused. But the law is clear. Such people can be reported. Even a stranger can report, but it's unfortunate this reporting is not forthcoming in most cases. I've just finished doing the gender-based violence and femicide work. And the biggest danger to children is the silence that surrounds their abuse. I met mothers who live with husbands who have continuously abused infant children as young as 3 years, 4 years, be it boys or girls. They have been defiled and defiled, but these people cannot report. If they dare report, then they are disowned by everybody. And you can imagine, these are the most vulnerable section of our society. They cannot defend themselves. They cannot run anywhere. It is such a horrific thing. But we need to create awareness around it so that we demystify all this thing about a family. Family which is supposed to be a loving place, and yet so much is going on that endangers the lives of these children. So we have the law, we have the administrative structures, the reporting channels and mechanisms, but they are suffering in silence. But the law is there.
Yeah, and it's indeed, sad that there's quite a lot of silence over this child abuse, despite the magnitude at which it's happening in our society today. And Judge, I don't know what you think. In as much as you say we have institutions, we have the law, what in your thinking is the gap? Yeah, there is fear, there is stigma. We have the institutions, we have the law. So where is the gap? Is the gap in the law? Is the gap in the enforcement? Where exactly should we work towards reinforcing the weaknesses?
I think the gap lies in enforcement. Enforcement is not optimal because people don't utilize those channels. So the law is there, but it's not being utilized. What we need to do over and above law, above enforcement, is creation of awareness around the abuses of children, so that we heighten the need for enforcement. So where, for example, children are abused, and then people report to the police, sometimes the police don't take up the matter. They think it is a family issue, or, children, they dismiss it. That is an enforcement issue, and we need to change the thinking culture among our law enforcement agents to ensure that they enforce the law. So enforcement is the big gap. Our own attitude towards children is a problem. I mean, you can imagine you watch a child of 4 years has been defiled and you keep quiet. Can we imagine the pain that child has gone through? I think we came across a case in Garissa or somewhere in Northeastern where a child of that age was defiled until the intestines came out. Some good Samaritan picked this child from the road with intestines hanging. And of course, the mother hasn't reported. It is this stranger who carries this child and takes him to hospital. And then the culture of silence. Everybody comes in, oh, don't talk about it, or don't. I mean, children are suffering in silence at the hands of their own keepers. So our culture, our beliefs, our own attitude towards child protection is one thing.
Okay. That is sad. And Judge, I know you have talked about the child desk at the police station, the child protection officer. Maybe just to make it more clearer, yeah, when we witness these kinds of violations, what are these avenues that we can run to? Because sometimes I have also witnessed instances where the local barazas, yeah, they sit to decide cases of defilement. And you keep asking yourself, do this really have jurisdiction over this kind of abuses on our children? So what are these legally recognized avenues that the public should be running to?
I think I have mentioned the police. I have mentioned the children protection officers under the Children's Act, where people can formally go to report. You can report to the chief. You can report to the ligurus. What are ligurus in English? Nyumba kumis.
Yeah.
I think we should utilize those avenues so that we don't strictly think it should be the police. I think it can be taken at any level, but the structures of reporting are quite clear in the law. The police, the child protection officers, but sometimes they are too far for somebody to run from their village looking for a police station. It may not be very near. So you can go to anybody, any authority. You can go to the chief. You can go to a neighbor who could be more courageous. You can go to Nyumba Kumis and report. It's not just restricted to the police.
Okay. And now let's look at instances where the perpetrators, those who have violated these children, are arrested. Yeah, we have witnessed instances where the child victims are taken up into rescue homes, which is a good thing. But then one wonders whether it is counterproductive, because just, removing a child from their home and placing them in the rescue homes, it looks like this child will not be comfortable, yeah, and they can easily suffer emotional trauma, which is a double suffering, yeah. They have suffered in the hands of their abusers, and they are now suffering emotionally in this strange environment that is a rescue home. And besides this, we have also witnessed scenarios where children overstay in these rescue homes, yeah. I've come across an instance where a child has stayed in a rescue home for over a year, yeah, meaning that their education is going to be compromised. Judge, do you think this is counterproductive of what we want to achieve for our children?
Absolutely, it can be counterproductive. Legally, a rescue center should not hold a child for more than 3 months. It shouldn't. And when they are taken into these rescue homes, the ideal situation is that they are given psychosocial social support. that their other needs are not interfered with, that their schooling is not interfered with. How far we get on that is now the problem. But the assumption is they should get psychosocial support. And in fact, when a child is rescued from an abuser, they should go through those processes of psychosocial support, of the children officer assessing their situation, if they need medical attention. That should go hand in hand with being rescued and put in a rescue center. And of course, it should be for a maximum of 3 months. And then he gets reconnected with the family. But if it is the family itself which is abusive, then maybe from the rescue place, they can be taken to an alternative family care facility.
Okay, thank you, Judge. And supposing we have instances of this prolonged stay in rescue homes, what steps should I take as a member of the public who has witnessed the violation? What role do I have to play in order to make sure that this child is not overstaying in this children's home? They are being transferred to the right place at the right time.
I think it's incumbent upon you as a member of the public, a person who has witnessed the abuse, to raise it with the authorities about the overstaying of the child, about the extra abuses that could go on. If a child is in that rescue center and is missing out on school, that is an abuse, because education of a child should not be interfered with. So subject to psychosocial examination and evaluation, that child's education should not be interfered with. That would be the ideal situation. But we should raise those concerns. A child should not stay in a rescue center for more than 3 months. A child should not stay away from his family or parents unless it is absolutely necessary, unless it is proved that the parents the child cannot be safe with those parents. Whereupon then the law requires that that child can be moved to a foster care home, or be adopted, or be taken into a kinship setup, what we call the alternative family setups.
Okay. Thanks for that clarification. And now let's look at this child who is a victim of abuse. But again, in addition to that, they are witnesses in a courtroom. What kind of legal protection are they entitled to, Judge?
Children are not supposed to face their accusers face to face. They can give their evidence either in camera or away from these abusers to avoid re-traumatization. Children are entitled to legal representation. Our constitution, I think if we look at Article 48, running through to Article 50, there are those rights for the child: representation, dignity. They should be treated with dignity. They should be treated with care. The courts in which they are being taken should be child-friendly. And all this is contained even in the international instruments, the CRC, the African Charter, the Beijing rules. They are all contained there, our own constitution, our own Children's Act, etc., etc. So they are entitled to care, entitled to their privacy, entitled to representation, entitled to a suitable court process. And then, of course, the ultimate goal is to have that child rehabilitated through diversion, for example, so that they go to get rehabilitated. The eventual aim is that they get reintegrated in society.
And what would you advise me to do as a lawyer or as a member of the public where I feel the court before where the children are appearing as witnesses are not according the child these kinds of protection?
We should raise the issue. The law is so clear. If we get into situations where children are being tried together with adults, that is contrary to the law. And we should raise it with authorities. If we see a court which is not suitable for a child or for the dignity of the child, we should raise it with the authorities because that is contrary to the law. If we see a courtroom in which children are being exposed to their abusers, it is contrary to the law, and it is incumbent upon us to raise that with authorities. We can do all that. Lawyers can make applications about the unsuitability of the court environment, about the unsuitability of the proceedings themselves, about the unsuitability or the denial of the basic and fundamental rights of the child facing trial, facing,
Witnessing.
yes.
Okay. Now let's look at the Children's Act, which you are central in its drafting. And one of the things that the Children's Act criminalizes are harmful cultural practices, such as, early marriages, female genital mutilation. Judge, can we say that as a country we have won the war against female genital mutilation?
I should say it's work in progress. Recently, I was reporting at the UN in New York on the status of FGM in Kenya, and apparently globally, Kenya is doing very well. It has reduced the instances of FGM to, I think, 35%. So it's work in progress. But we still have FGM going on in very many parts of the country. And this is because of the entrenched cultural norms that still defeat the law. Otherwise, the law, again, Article 53 and the Constitution, the Children's Act, international law, the African Charter on the Rights and Welfare of the Child is very, very robust on FGM. But we still have those entrenched norms that still enable FGM to continue. But Kenya is on its way, like reducing. But then there is another danger. There seems to be a resurgence of FGM in the most unexpected areas of this country, where we thought as a country that was a forgotten thing. Central Province, for example, we thought it wasn't there, it died, but there is a resurgence. And now also there is the medicalization of FGM. So that whereas efforts have been made in the past years to educate the ordinary people about the need to move away from FGM as a measure of what is it? Why do they circumcise? Because they think it's a rite of passage. A child who is circumcised, then it marks maturity and she can get married. So there have been a lot of campaigns against that. And the traditional circumcisers have actually, in most cases, downed their tools, and other forms of rite of passage have been adopted. But then there is a provision in the Anti-FGM Act of 2012, which allows cutting for medical reasons. But this one now is being utilized by medical doctors to actually do routine FGM on infants. It is so rife. When we were doing the femicide work, we found it in Kisii and in Nyamira. Now the medical doctors are the ones violating these children under the guise of that provision of medical requirement. So it is complicated. It is researching, and then it is also being medicalized. Whereas the one would say there is progress, there is also there are also challenges that we still face as a country.
Yeah, so maybe we can say it's sad, it's an evolution, yeah? So changing the form so that it's not the normal form that we are used to. And Judge, let's now talk about child marriages, yeah? The Children Act makes this a crime to marry off a child who is underage. But we also still see this being prevalent in several parts of our country. Why do you think drives families to continue, arranging these child marriages? And how can we then, just try to align the culture and the law in order to protect our young girls?
I think we are very progressive in making laws, but we hardly connect that law to lived realities of people in around the country. We don't. So there is that disconnect. We have the law, which many people are not conversant with. But again, the biggest problem is our cultural norms and cultural attitudes. The norms are so entrenched that the parents defy the law and still get their children married. Issues of poverty. Children, girl children have been a source of survival for most families. So it still goes on. The poverty thing, the cultural thing, the power imbalances, the lack of awareness in some parts. Came across them in Turkana, so the law is very distant from the lived realities of these children. So what I would say is we should make law, but ensure that that law is enforced. So it's not enforced. The law enforcers are just part and parcel of that same community. And in most cases, they even aid and abet the early marriages of these children. So law enforcement is lacking. Cultural norms are still very dominant.
Wow, and closely related to this, Judge, are teenage pregnancies. Yeah, and we all know that this is a national crisis where thousands of school-going girls give birth every year. Beyond punishing the offenders of this abuse, what practical interventions are there that we can say resort to this and we shall protect the girl child, or how do we prevent this, or if this shall continue to be a cycle repeating itself over and over?
Very important question. Teenage pregnancies, most of them result from defilement in the homes, in schools, teachers defiling these young children, and people turn a blind eye, and especially when it comes to teachers. Very little happens to them, although the TSC Act, although the law that we have prohibits that. But where it occurs and the child or the girl child infant finds herself pregnant, the law, both the regional law, the African Charter on the Rights and Welfare of the Child, obligates the states to put mechanisms in place to ensure that these children go back to school. And Kenya has a good, robust law and policy that allows for these children to be allowed to continue with their education. So there is the law, there is policy. Such children can be helped to continue with their education, be nurtured to give birth safely, and then again be assisted to go back to school. If they face stigma, if they face other barriers in the school in which they have been, they can be helped to go to a different school. But the bottom line is those children's education should not be cut short. Policy is in place. The law is in place.
And let's now look at protection of children from domestic violence. I think you have already mentioned the fact that, domestic violence is rampant. Yeah, it's quite rampant. We see it every day in the social media, in our news, in the courtrooms. Judge, to what extent has the Protection of Domestic Violence Act achieved its objectives of protecting children from domestic violence?
So the protection from domestic violence deals with all issues of domestic violence, and of course, violence against the children is also covered under there. So it provides, it has provisions on the protection of such children. They can be removed from the status, from the houses, and be taken to safety places, to safety houses, and go through that process, just to be removed and be protected from the violence within the domestic arena. So the law provides for that. The Protection from Domestic Violence Act does provide for that. As to whether it has achieved its aim is again debatable. I think we have a long way to go to obtain maximum protection of these children. And of course, that takes us back to the reasons why. Domestic violence is a very secret thing. People don't report. Parents themselves don't report. Parents themselves are abusing the children. Society is silent. You can pass your neighbor's house. There is violence even against children going on, but people never report. If I may talk about the femicide thing, which is quite the GBV thing, which we've been doing, is same scenario where abuses within the household, within the domestic arena are deemed to be private, and people should not intervene. Notwithstanding the fact that the penal code, there's criminal processes in this country, the law allows the police to move into that place and remove the child to safety. But we don't report. So probably we'll come to a stage where we have proposed a law, what we call the citizen obligation law, which places an obligation on each one of us to report, failure to which you face criminal consequences. So that if you see children being abused in that household and you think, oh, that's a private thing, you will have broken the law. So I do hope that we reach that stage where we all have an obligation towards children found within the domestic arena.
Okay, thank you. And I'm just thinking to myself, supposing, you witness this happening to your neighbor, and you just grab these kids and you want to take them to a shelter home. What are some of these examples of shelter homes that one can run to, or one must always look for a police station?
Now, there are shelter homes in most counties, although most people don't know about them.
Yeah.
So the quickest and most accessible place is the police or the the police or the child protection officers envisaged under the Children's Act. But as citizen, any citizen can take that child. If the police is far away, again, report to the next authority, the chief, the nyumba kumi, to the next neighbor. I think you can report and it can be picked from there. The shelter homes are the ideal. They should be everywhere. The safety, the shelters that I spoke about when we began, as envisaged under the Children Act, should be there and accessible. But unfortunately, I do not think they are everywhere. They are not in the established in many places. But under the Children's Act, that is the duty of the county government to ensure, and sub-counties, to ensure that they have set up those safety shelters for children. So where they are in existence, you take that child there. Where they are not in existence, take those children to the nearest authority, to the police, etc.
Okay, thank you very much, Judge. But I think perhaps this is also a wake-up call that we need to create a lot of awareness amongst the members of the public so that they know, where are these shelter homes, who do I report to, where do I report? Sometimes the police stations are not always very close, especially in the rural areas. Now let's talk about cybercrime, cyberbullying, and the protection of our children. Judge, with the increased online access, especially to the young ones, how protected are our children?
Yeah, that is a worrying situation in the country and I guess world over. But in Kenya, we have the law. We have the law. The Children's Act protects the children against cyberbullying, against these online offenses. It does. We have those provisions in the Children's Act. We have in the Cyber Crimes Act, which also protects children from the cyber crimes. So we do have the law, but it should go beyond just having the law. I think it is becoming incumbent upon parents to be more careful with the children, to ensure that they know what is going on with their children, especially when we have these gadgets given to them. I think they should be monitored to ensure that they are not accessing dangerous stuff on the on the uh, those abuses on on the whatever the cyber abuses. So again, it comes to additional vigilance over and above the law, but the law is there. As to whether it is adequate or not, is probably something to look into. But as we speak, there is a law that protects those children.
Yeah. Yeah. So thank you very much, Judge. One of the worries I have with the law, it's good we have the Cyber Crimes Act, but again, when you look at the crimes under this law, they are more responsive, yeah, and not preventive. In which case, when we are talking of vulnerable individuals like children, you discover that by the time you're getting in terms with the perpetrator and the victim, perhaps the worst will have happened. And so I think one of the challenges we really need to look into is how to prevent or preempt some of these abuses from happening, rather than just relying on what the law and its nature, limited nature is. And so, Judge.
Absolutely, absolutely. There are countries which have come up with very drastic regulations. In fact, banning ownership of these gadgets for children up to a certain age. Some have taken that drastic action. Our law, we need to rethink, as you say, we need to revisit it. We are always trying to prevent, to cure, but hardly do we prevent. So probably we need to go there and see what amendments we can make to the law.
Okay, thank you very much. That brings us to the end of our conversation. We now turn to a few questions. We hope that time will allow us to respond to all, but if it doesn't, please forgive us. And we will move to our first question from Gladys Onyango. I think the question doesn't read quite complete. But I'll move to the one that looks a bit more complete. The current Children's Act of 2022 explicitly prohibits corporal punishment and degrading treatment in detention centers. How do you reconcile the persistent gap between legislative frameworks? Maybe we can take two so that we move faster. Commitment to rehabilitation, the ground reality of institutional abuse, moral. I think this one is also jumbled up. I can't get it quite complete. Then let's look at another question from Anthony Wesonga. The issue of juvenile recidivism, can it be as a result of dysfunctional families? What is the end game to such?
What was that one, Mwalimu?
The issue of juvenile recidivism. Is it a result of dysfunctional families? And what is the end game? Then again, Dr. Nancy, this is Mohammed Ibrahim, how do you think we balance cultural practices with child rights protection to avoid conflict between communities and law enforcement? So maybe we can take those few, Judge, before we proceed.
Okay. The first was corporal punishment. Corporal punishment, a big nuisance. It has been there, especially in our schools. But now the Children Act is very, very explicit. It prohibits corporal punishment. The Beijing rules, and I think the CRC also prohibit corporal punishment. But again, like In many other situations, the disconnect between law and practice and the realities. People still met out corporal punishments. Even in the homes, we read and hear about cases where children have been beaten to death in the name of discipline by their own parents, by teachers. In fact, very horrific cases come out of that in spite of the law. So again, enforcement and also creation of awareness around corporal punishment. So that all the families, the parents know that it is a criminal offense to administer corporal punishment on a child. So the law is there, but implementation is problematic. The other one, how do we balance culture and the law? Our constitution, I think, gives us direction on how we balance the law and culture. Retrogressive culture is prohibited under the constitution. The constitution encourages progressive culture. I think it's Article 145 or something, if I'm not wrong. So that what is actually retrogressive, things like FGM, things like early marriages are retrogressive, and therefore the Constitution discourages them. And the provisions of the Constitution took into account the benefits or lack of them of some of those practices. So if we strictly go by our Constitution, then we can balance what is good culture and what is bad culture. If you go to the African Charter on the Rights and Welfare of the Child, it recognizes good culture, good African practices, in the context of children. But what is retrogressive is prohibited.
Yeah.
So there is that balance. We can always go there.
Okay, thank you, Doc.
And
Eric Kibogo.
Wesonga's question was what broken families? What was his question?
The issue of juvenile recidivism. Can it be
Yes.
as a result of dysfunctional families? And what is the end game to such domino effect?
Broken families is a contributor to a lot of juvenile behavior. It's a contributor. And so it is something that contributes, and it is quite rife. Most of children who come in conflict with the law, most children who need care and attention, and attention within the context of the Children's Act are from broken families. The street children, the majority are from broken families. So the dysfunctioning of families is a reality in Kenya. And again, our individualistic lifestyle that we adopted. Africans were never like that. We were different before the colonialists came and gave us these individual lifestyles, which has led to a lot of dysfunctioning in the families, the poverty in families, the abuses, domestic abuses in the families. And that contributes to the status of the juveniles in this country.
Thank you very much, Judge. Another question from Kibogo Eric. Honorable Doc, Nancy, legal purist as Hans Kelsen claim that law is pure. A different set of lens that I largely subscribe to, for example, critical thinking, critical legal thinkers, and its offshoot as feminism. See law as being laced with impurities such as cultures, danger, gender, etc., gendered law in brackets. In your objective assessment, to what extent are the laws peculiar to children, pure or impure?
Yeah, Hans Kelsen propounds the pure theory of law, that the law is a science, it is pure, it should be cleaned of all impurities, politics, social problems, economics, etc., etc. It is a science and it is pure. That is how he sees it. So that once a law has been promulgated, we treat it as such. It is meant to treat or address our social issues. That's how I think Hans Kelsen would see it. But the critical thinkers, including feminists, disagree with that law is laced with impurities, so to say. Law for the feminists is a reflection of the worldview of men. The men make the law, etc. The critical legal thinkers, law is nothing but politics, probably serving the interests of the majority, the dominant class, to the exclusion of the marginalized, the vulnerable. And therefore, when we are creating the laws, and especially for children, and children are very vulnerable, then I think most of these so-called in Kelsenian lingua, the impurities must be taken into account. Otherwise, we come with a law that is so disconnected from the realities of these people. And probably if we brought children on the table when we are drafting the laws, we could end up with different laws. I know, for example, was it in Zambia? I think in Zambia, when they were making their constitution, they made sure they involved children. Children came to participate and give their views. Here, we did not do that. And they are the most vulnerable. They are the most neglected. They are the most abused. And most likely, the law that we create does not reflect their realities. So I think that would be my answer. And sadly for us, we are very, very positivistic. And most times we go by Kelsenian thought. But our constitution allows us to be critical thinkers in our approach to law, in our approach to social phenomena, to the children's rights, to the rights of the marginalized, the vulnerable.
Okay, thank you very much for just clarifying on that particular question, Judge. Now we have another question from Tamara Ogot, and Tamara is saying, good evening, Dr. Baraza and Dr. Sala. You've talked on the issue of enforcement of children's rights. What organizations are supposed to check, or rather hold accountable, the law enforcers? I think she's relating to the law enforcement that are lax, at carrying out their duties. Then we can take a second question from Gladys Onyango.
What was that one, ma'am, before you move on, Dr. Irene? From Ogot?
What organization are supposed to check, or rather hold accountable, the law enforcers, the law enforcement? So Yeah, I think that's where she stops with her question, but I'm just trying to maybe elaborate on it, perhaps where the law enforcers, because we had pointed out that there's a gap in the enforcement. So who should check on them and hold them accountable? And then we have another question from Gladys Onyango, teenage pregnancy from a different perspective. I have come across several situations where teenagers have consented, yet it is only one side that suffers. The law punishes the boy child. Again, Dr. Baraza, much as we have seen this gap being recognized, how far would you say we are to achieving equality with regard to this matter? I think let's deal with those, Judge.
Equality of which matter?
I think she had previously talked about the, instances where teenagers consent to sexual behavior. Then the lady ends up pregnant, but the boy is the one who is being punished. So she proceeds to ask, how far would you say we are to achieving equality?
I think let me start there. Is quite a problem that we are confronted with as a country. The Sexual Offences Act, which tends to treat the girl children as the ones who are underage, below 18. The law should protect them, but the boy child who could be same age, and then they two have consented, strictly the law tends to side with the girl. There is a debate that has been going on. Should we revisit the law? Probably this is a debate that we should pick up, because we had come experiencing instances where jails are full of these young boys. The Romeo and Juliet cases, and I think the courts have ruled on it, but it is a problem. Probably the law needs to be revisited, because now who has defiled who? Okay,
Yeah.
so much as I was in the middle of making the Sexual Offences Act, I think there are emerging concerns which need to be looked at. That is an issue that should be looked at. So there is apparently there's no equality there. So it's something that a debate that we need to engage in my view. Then what organizations to hold accountable? Law enforcers. So where policemen fail to enforce the law, for example, they should be reported to their bosses, because they are obligated to enforce the law. But in most cases, for so many reasons, they don't. But those should be disciplinary cases with their employers. But we have this problem of law enforcement not being very strong on certain issues, especially when it comes to family issues, domestic issues, children issues. But we need to re-educate these police to change their attitude towards their work. Otherwise, it should be a disciplinary issue where, for example, someone has reported child abuse and the police takes no step. that should be reported as a disciplinary issue to the employer, in my view. Otherwise, in this country, we need a whole awareness creation, a whole training of these law enforcement agencies so that they take their work seriously. That is lacking.
Yeah. Yeah, because Judge, I do agree with you, because one of the main challenges that has arisen insofar as the internal police disciplinary mechanism is concerned is that, we have the same people dealing with the same people, in the same, kind of setting, which makes it really a challenge for a civilian just to have to feel like they have justice, because then it becomes very problematic. But again, we can't give up. We keep hoping that one day the tables will turn and justice will be found. We have a comment from Rachel Mwendwa. Agree with Dr. Baraza on children within domestic arena. Many times we tend to turn a blind eye. Then Judy AMN, how to rescue a child has reached age of majority, but still a dependent for school fees, support, and upkeep from abusive relatives financially. I think the sentence is so broken down, but I don't know if you figure out what the question is all about.
How to rescue a child
who has reached the age of majority, but still dependent, maybe on the parents for school fees, support, upkeep. No, not necessarily rescuing from parents, but from abusive relatives. But still dependent for support, but they are mature age. So how can a child be of mature age? Judge, maybe you know this better.
A person ceases to be a child when they hit 18. So there they are no longer children. But there are those who are above 18 and they are still dependent. And there are also people whose rights are guaranteed under the law, under the Constitution, under the law, so that they cannot or should not be abused just because they are above the age of 18. So first and foremost, they are human beings. They are persons who are guaranteed security under the law. And when they are still dependent on those people, again, I think if it is reported to the law enforcement agencies, I think steps can be taken to ensure that their rights or their welfare is guaranteed. Court action can be initiated to show that failure to be supported by the relatives is detrimental to that person. I think legal action can be taken to go and demonstrate in the courts that you may be a grown-up. First and foremost, your rights are being abused. And secondly, you need economic and social support. I think that can happen, or it should happen. But the level of helplessness and hopelessness is what is leading to violation of the rights of almost everybody in this country.
Okay. Thank you very much, Judge. Now we have our last question from Sheila Bahati. Good evening, Doc. Can a biological father custody rights be overridden by a stepfather who is presumed to have adopted a child? Sheila, I would advise you to tune in in our next session next week, where we shall exhaustively discuss the topic on protecting children in succession and divorce matters. But nonetheless, Judge, since the question has been raised, perhaps you can just respond to this.
Repeat it, ma'am.
Can a biological father custody right, a biological father's custody rights be overridden by a stepfather who is presumed to have adopted a child? So I'm thinking of a scenario, of the current happenings, where you find the parent, the spouse who has custody dying, and they had remarried. And now we have the tussle between the surviving stepfather and the biological stepfather. Can we say the surviving stepfather overrides the right of custody over the children over those of the biological father?
Okay, and she started off by talking about adopted. Now, adoption is a whole concept, and you know what amounts to adoption. It means biological parents relinquishing all their rights over that child in favor of the adopting parents. So that is a whole process which changes the scenario.
Yeah.
But assuming it's not an adoption, there is a step father, a father who married the mother of the child, isn't it?
Yes.
And the biological, of course, the law is quite clear. The biological father has rights over that child. That is guaranteed under the Children's Act and the Constitution. So it doesn't, he has rights of access, rights of support, shared parental responsibility, and so does the stepfather who has the physical care of the child, so that none of them is superior for the well-being of that child. I don't know if I have answered it correct,
Yes,
but maybe in the next session. But what I do know is that a biological father has rights, an adoptive father has rights, a foster father has rights.
Thank you very much, Judge, for this quite enlightening session that you have taken us through, quite a number of issues that concern protecting our children whenever they fall victims to abuses, the different forms of abuses, the different protection mechanisms that are there, and what we need to know and do as members of the public, as lawyers, as law students. And I have no doubt that every person who attended this session will leave it feeling very empowered, because knowledge is power. So thank you very much. This brings us to the end of this talk tonight. Just to extend a big thank you to the audience and to encourage you to subscribe so that next time you don't miss out on the notification of our next discussion, because we shall have many more of this kind in the future. So thank you, everyone, and good night, and God bless you.
Good night. Good night. Bye.
Bye.